What happens if a tenant ignores your notice to vacate? Imagine sending a clear message to a tenant that it's time to move out, but they choose to ignore it. What really happens next? Well, ignoring a notice to vacate is more than just a silent treatment. It triggers a formal legal process that both landlords and tenants need to understand. A notice to vacate is a written document from a landlord telling a tenant to leave the property by a specific date. It's usually required by law before starting any eviction process. Landlords might send this notice for reasons like unpaid rent, lease violations, or simply because the lease has ended. If the tenant doesn't leave by the date on the notice, the landlord can't just change the locks or remove their belongings. That's called a self-help eviction, and it's illegal in most places. Instead, the landlord must begin a court process called an eviction or unlawful detainer action. This involves filing a lawsuit with the local court. The landlord needs to show proof of the lease, the notice to vacate, and evidence that the notice was properly delivered. Once the case is filed, the court will set a hearing date. If the tenant doesn't respond or show up, the court can give a default judgment in favor of the landlord. If the tenant does respond, both sides get a chance to present their case. If the court rules in favor of the landlord, it will issue an order called a writ of possession or warrant of possession. This order legally requires the tenant to leave the property by a certain date. If the tenant still refuses to leave after the court order, the landlord must ask local authorities, like a sheriff or bailiff, to physically remove the tenant and their belongings. Only these officials have the legal power to do so. Landlords cannot do it themselves. Once the tenant is removed, the landlord can take back possession of the property. There are usually rules about handling any belongings left behind, so landlords should check local laws. Throughout this process, landlords might face costs such as court fees, legal expenses, and lost rent. If the court finds in the landlord's favor, it might order the tenant to pay back rent or damages, but collecting those can be difficult if the tenant has limited resources. Tenants have rights too. They can challenge a notice to vacate if they believe it was issued improperly or for an invalid reason. Common defenses include improper service, property issues, or claims that the eviction is retaliatory. If a tenant raises a valid defense, the eviction process can take longer. For landlords, keeping detailed records of notices, payments, and communications is essential. Following the legal steps carefully helps avoid delays or dismissals. Consulting a legal professional familiar with local landlord-tenant laws can also improve the chances of a smooth resolution. For tenants, understanding their rights and seeking advice if they get a notice to vacate can help them respond properly. Whether that means moving out, negotiating, or challenging the notice in court, knowing the process is key. Ignoring a notice to vacate doesn't make the problem disappear. It just leads to a court-supervised eviction, which is designed to balance the rights of both sides. Both landlords and tenants benefit from knowing their legal options and acting within the law.